Hello, Landlords Attorney Garcia, Landlord Attorney. I'm happy to be joining you this Friday morning as we go live to talk about your security deposit and what you should be doing to make sure that the security deposit funds that you're holding are used in the absolute best way, not necessarily the way that is best for your tenant. And so as we get going, Olga, can you turn that this way, please? As we get going, I want to make sure that we answer all of your questions. If you have questions that you have not sent to us yet, please go ahead and send those in the stream. We'll be watching out for them, and I'll do my best to get to all of the questions during this stream. But I want to talk in general about a few things having to do with security deposits and what I recommend you do when you're faced with challenges from your tenant regarding that deposit. And the very first thing is, if your tenant is demanding that you use your deposit for anything, whether that's late fees or repairs or unpaid rent, the first thing I want you to do is go to your lease. That written agreement probably already addresses precisely what the limits are as to the use of that security deposit. Any good lease anyway should say that the lease is not to be used for rent and is in the sole discretion of the landlord. And that should be the case. The deposit is there for use as security, not as a backup for payment for that tenant. Now, and I do want to address this because I do know that this goes out in multiple jurisdictions. If in your jurisdiction, there's a specific rule that somehow allows the tenant to dictate how the security deposit is used, well, that's its own thing. I'm talking specifically from the state of Texas, where I know that's definitely not the case, where the tenant cannot come to the landlord and say, you must apply security deposit funds in this way during the tenancy. Now, what we know generally is when a tenancy ends, that the security deposit, definitely in the state of Texas, is presumed refundable back to the tenant. So the landlord has the presumption that that security deposit will be returned to the tenant. But again, that's after the tenancy has ended, after the tenant has vacated. In Texas, the landlord has 30 days, and the same is true in many jurisdictions. But in Texas, the landlord has 30 days to get that back, along with an itemized written document that explains how any funds that were removed or used from the security deposit, how those were applied to the tenant's account, so that the tenant is fully aware how all the funds in the deposit were used. Now, some states also require that the landlord put those funds in an interest-bearing account and that the interest goes to the tenant. That's not the case in every jurisdiction. And that's not precisely what we're talking about. We're not talking about interest or fees or the kind of account that you need to use. Instead, we're talking about the bare bones use of the security deposit itself and what I recommend. So if your tenant, for example, suggests or even demands that any late fees or any damages to the property that they have caused should be removed from the security deposit, you certainly can do that if that's what you elect to do. But I would argue that those moves make you a lot less secure. Number one, you're not in any way sending a clear message to the tenant that the things they get wrong, like late fees and repairs, that they are 100% culpable for, the things that get wrong have instant ramifications. Your property is not supposed to be damaged. But if it is, you have the security deposit there to protect you. But again, hold that to the end because you have no idea what damages are going to lurk once the tenant is gone. And so you want the maximum amount in your security deposit there at the end of the lease so that if you are shocked or you are surprised because you haven't inspected or something happened on the move out, you're going to be okay. If you're depleting those funds during the tenancy, you're going to be less secure. Absolutely. And it should be that a tenant who incurs late charges or who incurs repair costs due to their negligence or due to misuse should be paying those fees within a 30-day period or so. It should be within a reasonable amount of time that they are billed for those costs and they are assessed those fees. If you have an application of funds clause in your lease, which says, hey, if I get money from you, I can apply it first to any obligation you already owe and then to rent. That's your best setup. I wouldn't take it out of the security deposit. I would take it out of a subsequent payment. And if it's short because they did not include the late fees or the repair costs, well, that's something they're going to have to deal with. And you should issue a written notice to the tenant saying, look, you covered last month's late fees, you covered last month's repair costs, and the balance was applied to rent, but you still have a shortfall in unpaid rent. If you have an application of funds clause in your lease and you can utilize that funds clause in that way, that's always my recommendation. When it comes to rent, however, if someone says, look, I really can't make the rent this month, just go ahead and pull it out of my security deposit. What they are telling you unequivocally is they cannot afford to stay on your property. And so don't ever again decrease your security as a favor to the tenant. What you should be is cognizant of the fact that the tenant simply cannot afford to remain on the property and that it's probably time to part ways. Sometimes things change. Sometimes things could go badly or unexpected costs arise for the tenant that make the monthly rent difficult. But if you're going to bail them out with a security deposit, again, you're going to make yourself less secure on the back end. And don't come to me and tell me, well, Ernie, they promised me that they will pay extra over the next few months to re-up that security deposit. I've seen that go so wrong so many times. Unfortunately, if they cannot pay within, again, my philosophy, 7 days, the full amount of rent owed for that month, you really got to issue a notice to vacate. And you're saying, but I'm holding that security deposit. Isn't that there to help them? It's not. It's there to make sure that when they leave, anything that's owed, that money can be applied to that debt. But if they're going to risk an eviction, again, it's not up to you to bail them out with the security deposit funds. That's just going to make things worse for you. And these just aren't good business steps. Make sure that you have a clear policy in place so that if it turns out that your tenant simply does not have enough, you're not bailing them out. And if later they say, look, here we are 25 days later, I'm able to pay the next month and everything that was owed from the prior month, can we resolve this issue of eviction? Absolutely, you have that opportunity then. But I'll tell you that 9 times out of 10, that's not what occurs. If a tenant is unable to pay the full amount within 7 days, it is very unlikely that they will eventually be able to do it. For that 1 in 10 that can, again, it's up to you to simply reset the train right back on the tracks and keep on going. But you need to prepare for the other 9 who simply won't get that done. So make sure that when it comes to your security deposit, you are well educated as to what your lease specifically says or what the limits are of the use of that set of funds. And that you know what the law requires of you when it comes to returning those funds or applying them to any debt that's owed by the tenant. Typically, it is after the tenancy has ended, and you are the most secure reserving those funds for after the end of the tenancy. If you're doing it during the tenancy, you're making yourself less secure, and you're really encouraging bad behavior on the part of your tenants. Let's go to those questions. Number 1, we've got from Victor. Does Ernie organize landlord events in Houston? Yes, I do this pretty regularly, actually. And so I go to speaking events all over the city of Houston, sometimes as a guest speaker, sometimes we organize events. And so what we like to do for those of you who are in Texas or in the Houston area specifically and are not members of our Landlord Facebook group, I encourage you to jump onto Facebook, join that group, because we're going to post a lot of announcements there. If you're interested in getting on our mailing list so that you can be informed when these things come up, go ahead and shoot me an email at info@attorneyeg.com. That's info@attorneyeg.com. Shoot us a message, and I'll be happy to add you to that newsletter that comes out every single week with updates from us. And so
October. What's the review about it?
Okay, so we do have an event at the end of October. Again, that'll all be blasted through these different places in the Facebook group, on our newsletter, and if you've got questions, don't hesitate to shoot us an email and ask. Next, Misty asks, how do we know when something should be in our lease versus in an addendum? I try to keep things very simple and want one concise lease agreement as much as possible to keep things orderly. However, I have a few addenda, but wanted your input. Thanks for all you do for Texas landlords and for us. Well, thank you, Misty, for those kind words. So the lease should have all of the general items that apply to all of your property. So we assume that the lease is going to be used in a general way across multiple kinds of property. And so if that's the case for you, if you have 5 to 10 units, then the things that should go in the lease should be the things generally that apply to all of them. Now, certainly there are certain blanks, the amount of rent, the names of the parties, that's obviously going to vary from unit to unit, but the same basic terms apply to all of the units that you own, possibly because you purchase similar kinds of property. And so what your lease should be is a bit more generic. What the addenda are there for are where you laser focus down to the specific elements of that property. You may, for example, have certain equipment on the property that isn't applicable anywhere else. You may have one house that has a water softener. You may have another house that has a pool. You may have another house that has a shed. You may have some that has, I don't know, pseudo or semi commercial use, which is hairy. But you might be in that situation. And so because of all these variances between your properties, you want a separate document to handle those differences. So I like supplying addenda to leases because I like for the lease itself to cover all of your basics, but for your addenda to cover those very specific things. And here's the truth. Any addenda is part of your lease. It's an extension of your lease. It is just as enforceable as all of the elements of your lease, as long as it doesn't contradict your lease. So if you're having to sign addenda, or if your question really is, I'd like to eliminate the addenda and just put it all into one big lease, that might work for you if, for example, you have a handful of properties and they're all pretty much the same, or they're all exactly the same. You might, for example, have a fourplex and there's no difference. The common area is the same, the different rights and responsibilities, all the parking rules are the same. In that situation, sure, you can have one solid lease document, and instead of separate addenda, you can have one big lease. But if you're using your lease in a more generic way, then the basic lease should have those generic terms, but your addenda should have all of the specifics that apply just to that particular property. All right, so next question goes to Andres. I sent notice to an inherited tenant who didn't have to sign lease for a previous landlord. I see. So Andres, you appear to be asking, can I send a notice to vacate to an inherited tenant who didn't have a signed lease with the previous landlord? What I'm hearing is you purchase property with an occupant and an already established tenancy that may or may not have been reduced to writing. And so absolutely, once you purchase that property from a prior owner who had a lease, even if that lease was completely oral, you now own that lease. And so now your agreement is as though you were the prior owner. And yes, you can send your notice to vacate to that person. You can also, if the tenancy is month to month, terminate that lease and say, hey, by the way, if you want to stay here, you got 30 days. I'm going to terminate the current lease. And 30 days from now, I'd like to either A, have you move on, or B, have you sign this brand new shiny lease in my name with the terms that I believe are required for this deal to work out. And so if they agree, they sign. If they don't, they leave. And either way, you are fine. But yes, the notice to vacate or any notice that you send to that tenant, you send in the shoes of the prior owner. Again, it's as if you and that tenant had that oral agreement. Now, if the agreement previously was in writing and that prior landlord didn't get that lease to you, that's a complication, but it isn't one that can't be overcome. And so as long as you know the basic idea, well, we signed it back in 2015 and we never signed a new agreement, but I lost the lease. I have no idea where it is. Should it come to you proving up the case in court, you can always disclose that to the judge. There once was a signed lease. It has since lapsed into a month-to-month tenancy. However, I have no idea where it is. I purchased this property from a prior owner, and he or she was unable to get that to me. All right. So we've got one more question that I'm going to get to, but I do want to mention that some of you have already seen this out there because we've had it out, I believe, since was it the summer or from the spring, where we first launched our Texas eviction course. And some of you who've seen some of my videos have seen that we've produced a Texas eviction course. So this is specifically for landlords in the state of Texas who need some assistance but are not ready to hire an attorney. Because it might be that you're like, look, I'm pretty good at this. I'm on the 80th percentile when it comes to landlords, but I could use a little bit of help to get up into the 90 or beyond. And so what can you give me, Ernie, to help me do that? I'm going to give you exactly what you need, and that's an eviction course that goes from start to finish. Our Texas eviction course takes you from notice all the way to judgment, even judgment on appeal. And so what it does is it walks you through all of the steps. When do you send notice? What kind of notice should you be sending? I even give notice templates, and in these templates, I give you a step-by-step. Here's what goes in each section. Here's where you use it, how you use it, and when you should use your notice. And once you've issued notice and it's time to file, I even give you a sample eviction petition suitable in any court in the state of Texas. That sample eviction petition, I do the exact same thing. I walk you through each of the terms, how you should fill it out, where you should fill it out, and what to do once you are ready to file that eviction. I then walk you through what trial looks like, what you can expect, even settlement options that are there, what to do if there's a jury that's impaneled by the opposing party, and then what to do when an appeal is filed. And so this step-by-step process we talk about in multiple modules. And for the month of October, we're offering a $100 discount on that course. If you are interested, there will be a link in the description below, and there will be questions answered for you if you have questions. Again, info@attorneyeg.com, info@attorneyeg.com. If you have any questions, I look forward to helping out anybody who's saying, look, I'm pretty good. I want to go from good to great. What can you do to help me get there? Texas eviction from start to finish should be the recipe that you use to get from pretty good to great. I look forward to you checking out that course. $100 off during the month of October. So our last question, unless we got anything new that has popped up, our last question, and you're watching the stream? All right, very good. Can you talk about wear and tear of carpet and paint? What typically happens on a 3.5-year lease in regards to painting and carpet? What about small holes in the wall? Well, I can tell you that things are different from unit to unit. Certainly, if you've got one individual living in a unit, even for 8 years, you're going to have significantly less wear and tear on the walls, on the floors. And I'm speaking, kind of generally. You can have some pretty bad individuals who wear things out pretty badly. But imagine that one person living somewhere for 5 to 8 years is going to have a different wear and tear on a property than if 6 people are living in a unit for 3 years. And so, there's no one way to do it. What I recommend always is, number one, does the landlord have an adequate understanding of the property before the tenancy ever began? Does the landlord have the ability to prove to the entire world what the condition of the property was before that tenant moved in. You can't just show up to the court with an anecdotal reference. Well, I did this and I did this and I did this. Well, prove that you did that. Do you have receipts? Do you have photographs? If you don't, then it's going to be difficult for you to establish a baseline. But if you can show brand new floors, brand new carpet, shiny walls, here's a receipt for the paint that I paid for the entire house to be painted before the tenant moved in. If you're unable to establish that, I guarantee you the tenant's going to come in and say something completely different, especially if you're relying on an inventory and condition form. Because remember, if you're giving them 5 to 7 days to fill that out, guess what? Damage could occur during those 5 to 7 days that if put on the list and you have no other evidence to contradict, who's on the hook? You're on the hook, because the tenant's going to say, scratches on the floor, dents on the wall, da-da-da-da-da. Again, if they caused it or you caused it, it's a gray area. It's unclear. But guess who has the burden to prove that they caused it? That's on you. So the best way to do it is to establish a baseline before the tenant ever takes possession. The next is to be able to show the court what exactly the tenant did. And so you must know and be able to illustrate exactly what the tenant did and why you believe it exceeds normal use or normal wear and tear. Because there are some things that just aren't normal. You specifically cite small holes in the wall, probably from photographs. That's typically normal, and most courts just aren't going to award you $1,000 in rehab damages because there's a few holes in the wall. Now, if they painted the walls, that's different, because now if you're going to return the property back to its original condition, if they painted specifically without your permission, then they've got costs. But if you gave them permission and never required them to return the property back to its original condition, guess what? That's normal use. It's normal for someone to paint the wall when the landlord has given them permission to do it. So no, you would not be able to charge in that sense. So after 3.5 years in this example, what is the condition of the carpet? Can it be said that any of the damage on the carpet results from the normal use after 3 to 5 years? And the test is, what does it look like before and what's the after? Again, it's going to vary from situation to situation depending on the number of tenants and the way that the property is used. But unless you have those side-by-sides, it's going to be very difficult. And no, there's no one size fits all approach to this. It really has to do, what can you prove was the condition of the carpet or the wall before, and what can you prove is the condition of the carpet or the wall after. And if it makes sense that 8 years have passed, you have, again, less recovery. If 1 year has passed, you have a higher degree of recovery. After 3.5 years, you're kind of in the middle, and it's very fact specific. All right. Question number 5. What if a tenant refuses to provide a forwarding address after the tenancy has ended?
Follow-up question, right?
Can you get it to me, please? All right. What can you do if a tenant refuses to provide a forwarding address? What can landlords do? Well, there's a couple of things that I recommend in these situations. First, is there a refund at all? If there is a refund and you simply can't get it to the tenant because you have no idea where to send it, you do have at least one option. You could mail it to the rental property. If the tenant has forwarded their address through the USPS, then sending it to the rental house should eventually get it to the tenant. And so one clever way of returning a security deposit is simply by that method. Another might be if you know their place of employment. If you know where they work and you know that they are still employed there, then mailing this to their place of employment, again, gets the job done, whether they've given you the forwarding address or not. Now, some of you are thinking, well, Ernie, why would I do that? Isn't it their responsibility to give me their forwarding address? I don't have a duty to return it until they do. That's definitely the case in the state of Texas. The question is, if you can get it to them, why wouldn't you try to? You may still have a cell phone number. You may still have an email address. Just because they haven't given you a forwarding address doesn't mean you shouldn't at least try. Because what you want to be able to demonstrate to the court always, always, always is that you were acting in good faith at all times. You don't want the potential argument that something was done improperly. If you can get it to them, get it to them. Another option is if you just sit and wait, how long do you have to wait? Well, it's going to depend again from jurisdiction to jurisdiction. But in the state of Texas, you're on the hook for any refund that is otherwise owed from the moment that the tenant gives you that forwarding address and vacates. So it's a two-part. So they vacated, that's done. But they haven't given you a forwarding address. But when does it end in the state of Texas? In the state of Texas, it ends after 4 years. So why do you want to do that to yourself? Just wait 4 years in the event that they're going to get to you. Chances are they will, but you're better off just taking this off your books and finding them. But if it turns out that you haven't, that you've elected to wait, and more than 4 years have passed from the date that the tenant vacated, well, guess what? You get to keep the entire amount and you never have to justify any of it. That's probably not super likely to occur. Typically, you're going to get the runaround from a tenant who left knowing I left so much damage, there's no way I'm getting my forwarding address, or someone who just forgot and will eventually, typically within the next 6 months, come back to you and say, hey, whatever happened to my security deposit? And so you may have people who are not super knowledgeable on the process or simply didn't know they were supposed to leave a forwarding address who come back to you within the first 6 months. Which is why I would say, look, if you know that it's owed and you know a way to get a hold of them, you should make it a practice to send the money to them. Don't create a scenario where they sue you because they don't understand the law, and now you have to deal with that. So if you can clear it off your books, my strong recommendation is that you do that. Okay, and certainly if the damages left by the tenant exceed the deposit and you don't have a forwarding address to send them the itemized list of those damages, email, work address, or simply wait. When you're not holding money from them, instead you have a bill that they owe, it's a little bit different. And so then you have to go into the calculation, is it worth going after the tenant for anything that exceeds the security deposit? It might be, but if it's not, you shelve it until you get a forwarding address, or you send it to them at their work address or at some alternate address that they may have supplied to you, or through email. And so it's always a good idea to let them know how the deposit was used, again, as a way to prevent some silly wrongful withholding lawsuit that you might get hit with simply because the tenant doesn't understand the law and because you didn't properly inform them. Again, even if you didn't have the requirement to do it, if within 30 days you can do it, I strongly recommend that you do. So I'm thinking that is it. It looks like we got all the questions that we received. If there are other questions in the future, I look forward to answering those. I will be here every other Friday on YouTube. Next Friday, however, I will be on Facebook. If you're not yet a member of our Facebook group, I strongly encourage you, particularly those of you who are landlords in the state of Texas, to join us there. But until next time, landlords, happy leasing.